We will call to order the Board of Election Commissioners of the City of Chicago, constituting ex officio the Electoral Board to hear and pass upon objections to nomination papers of candidates for the offices of Mayor, City Clerk, City Treasurer, and Alderman in the City of Chicago. Good afternoon. My name is Marisel Hernandez. I'm the chairwoman. Seated to my right is Commissioner Kresse, and to my left is Commissioner Jonathan Swain. Next item on the agenda is any regular motions. We don't have any, so we will proceed with Rule 20 hearings, and today we will limit arguments on each side to 10 minutes on each of these Rule 20 hearings. First one is 19 EB ALD-005. There is a related case, 19 EB ALD-001, Brenda Hardy versus Guyinga, Washington, candidate for Alderman of the 29th Ward.
I'm Doug Ivendall. I'm here for the objector.
And I'm here on a companion case for the objector.
Say your name, please.
Pericles Abbasi, first name Pericles, last name Abbasi.
So, Mr. Abbasi, are you
I'm Ivendall, Doug Ivendall for Brenda Hardy in 0005.
Okay, and can you state your, spell your
Sure.
name for the record?
It's Doug Ivendall, Ivendal.
And is there anybody here for the candidate, Guyinga, Washington? Okay, I think we should pass this for a few minutes and see if the candidate arrives.
That's fine. Thank you.
The next case on the agenda is 19 EB ALD-105, Renee Elms, Peter Rivera, Renee Wozniak, Maria Origel, and Evelyn Raza versus Joseph G. Williams, candidate for Alderman of the 15th Ward. Is anyone here on that case?
Scott Erdman on behalf of the objector.
Mr. Erdman, it doesn't seem like the candidate is here at this moment. Would you mind?
Not at all.
We're going to pass it just a few minutes. Next case is 19 EB ALD-150, Kevin Bailey versus Jeanette B. Taylor, candidate for Alderman of the 20th Ward.
Good morning, Ed Mullen on behalf of the candidate Jeanette Taylor. I do not see Mr. Bailey here at the moment.
Again, maybe we could just pass it a few minutes.
That's why they can sit down.
Good. Next one is 19 EB MUN-014, Daniel David Gerhard Rogers versus Elizabeth Betty Arias Ibarra, candidate for city clerk.
Here, stepping up.
So just grab another chair there. Will the parties please identify themselves for the record?
Your Honor, Attorney Frank Avila on behalf of Elizabeth Betty Ibarra Arias, who's not here in her proper person, but her campaign manager Hector Escarzaga is here in his proper person. And Your Honor, I believe that for the sake of efficiency of this honorable board, that we should have two cases heard at the same time if possible. I don't know if that is possible from a procedural aspect, but they are the same issues almost exactly, if not exactly, with a couple little.
Well, let me find out what Mr. Casper's position is on that.
I'm Michael Casper and Kent Hartman on behalf of the objector in the case. There are some similar issues in both cases. I'm not sure that, so that's fine.
Okay. If there's no objection, then we could.
We should limit the time.
We are.
10 minutes.
I did state that at the beginning.
Well, since there's two cases, I'd be willing to do two for 15 minutes. I'm giving you guys a 5-minute cut.
12:05.
Deal.
Okay, and Mr. Avila, you have filed the Rule 20 motions in both of these cases?
I have, Your Honor.
Oh, well, I don't think I stated the second one. Let me just, for the record, it's 19 EB MUN-020 with a related case 19 EB MUN-024, Daniel David Gerhard Rogers versus Patricia Horton, candidate for city clerk.
Correct, Your Honor.
Okay.
Mr. Alva, you represent Mr. Horton?
I do. I represent Patricia Horton, who may be here in her proper person. She can step up. Madam Chair. So, Your Honor, again, Attorney Frank Avila on behalf of Patricia Horton, the candidate for City Clerk of the City of Chicago, who is here in her proper person, which is 19 EB MUN 20, and I am also the attorney for Elizabeth Betty Arias Ibarra in 19 EB MUN 14, and her campaign manager Hector Escarzaga is here, although she could not get off work today.
Okay. So what's the first issue? Let's try just that you'll be discussing. Is it the residency issue?
It's not residency per se, Your Honor, but I think the first issue, which is the most basic, and I could get rid of it rather quickly, is the issue of good faith and the issue of the appellate court case from this jurisdiction, which is Daniel V. Daly, 2015, ILAP 1st, 150544.
Okay.
Now, in that case, there's slightly different factual variables, although extremely slight. And I did actually not call the objector in his proper person to be called for the issue of where he lives. That was called by Mr. Casper for an evidentiary hearing, which I don't think should ever taken place. But we can get that in a second. I called him for a good faith hearing, which I am allowed to have by both case law and practice here at the board. And what I like you, if you have them, to refer to the transcripts, and I can give you the specific parts. But before I do, what I'll do is, if you have it in front of you, I have a number of documents attached, 18 specifically. I think one was just a case citation. But the case I did attach and was previously cited in our original Rule 5 motion to strike and dismiss brief, Daniel V. Daly, 2015, ILAP 1st, 150544. In addition, going along with the other cases that we cite in our initial motion to strike and dismiss, both of them being very substantially similar. And in those, in that, I talk about Daniel V. Daly, and I also talk about Prince v. Colvin, 08 EB RGA 33, CBC, December 7, 2007, and Young Curtis v. Lyle, 03 EB ALD 039, CBC, January 31st, 2003, finding it's proper to dismiss an objector's petition when not made as a result of reasonably inquire or investigation of the facts and were not made in good faith. And in this case, indeed, what you have here for both cases, although slightly different, is a case where these objections were not made in good faith. And I should note a very big distinction in this case. Both cases were verified petitions. That means they were verified that it's true under oath, either by notary or by a 1109 verification. So they're verified petitions that he swore are true to the best of his knowledge. However, when I ask him, for example, in the case of Ms. Horton, about what he knew about, not how he compiled them, because they're going to cite Nader, but what he knew about recapitulation sheets, his answer was, what are they? I don't know what they are. Okay? And all he could say in the case of Ms. Horton was there was a box in my lawyer's office. He did not know what the box was. If it was an open box, a closed box, the contents of the box, a jack in the box, nothing, zilch, zippo. And that's in the direct contradiction to the holding in Daniel v. Daly, which says if you have a verified objection, that the objector is held to a higher standard because he must know something about the objection. In fact, Mr. Casper even stipulates that he did not prepare it. Not that he had knowledge of the compilation, again, not in violation of Nader. We are not violating the Nader case. But he had no knowledge of it. He took no part in it at all. He was politically astute enough to know that 12,500 signatures is the required minimum. And he even admitted that not most people are not objectors, and Judge Ponsetto, hearing officer Ponsetto, took judicial notice that most people are not objectors in cases. So he had some political involvement. Yet when asked about the recapitulation sheets, which are in the text of the objection and attached in the objection, he didn't even know what they were. He said, "I don't know what those are." And I'm gonna get to the proper part of that where it says that. So he literally had no knowledge of the objection, did not review anything, and said he saw some reports in a box. In fact, in the case of Ms. Ibarra, he didn't even know what the objection was about. He didn't even know the nature of the objection. And I quote, "Did you ever examine the petitions of candidate Elizabeth Ibarra, Betty Ibarra?" And the answer was, and this is on page 46 of the transcripts. "I was provided a summary of the objections. I was showed the list of petitions. I, as a person, did not read every single one." So did you ever look, and the next question, did you ever look at any documentation to see if they could compare the signature to any sort of a signature to a record of any sort? And then Mr. Casper gave an objection in a leading question. And I said, "You saw a summary report, correct? Did you examine any data or records?" "I was provided a summary, I looked at files. I'm not the person who went through everyone and checked." "Every one of what?" I asked him. "Files." I said, "Files for what?" And he goes, "The petitions, yes." And then I go on to ask him about what even the nature of the petitions are, and he doesn't know. Doesn't know anything. For Ms. Horton, and I will cite to the record, that is when he goes on to say that he doesn't even know what recapitulation sheets are. He says on page 65, I asked him, "I saw a box of papers at the office." I asked him what was in the box. There was an objection, but he still answered. And he said, "I looked like everything in brief." And I said, "Did you look at any specific sheet and line numbers of Patricia Horton?" He goes, "I did not." "Did you review any documents for the Board of Election vis-a-vis any sheet and line numbers of the circulators of Patricia Horton?" "I don't believe so." "Did you prepare the appendix recapitulation sheets of Patricia Horton?" Quote, "I am not sure what that is." Page 66. The hearing officer even said, "I believe he said in his testimony he didn't review anything." And Mr. Casper stipulates he didn't do anything. And that's a appellate court case controlling here.
Okay, well, I want to stop
Now,
there.
I'll go on to the next issue.
No, that's why, I want to stop there because I want to hear Mr. Casper's response to this whole issue.
On this issue, you wanna go one at a time? Why don't we,
You want to just do
yeah, I'd rather
everything?
do it, because
Okay.
that will keep us under 12-5.
Well, don't have this as my time, please.
Stop the clock.
Yes, Your Honor.
Okay, Mr. Avila, what is the next argument?
So, you have ruled on two cases which were both attached into the Rule 20, which was Branch v. Teleferro and Harris v. Teleferro. I'll give you the exact case numbers here.
Well, they're
What-
attached to your Rule 20 motion.
That's
I can
correct.
read those, yes.
19 EB ALD 069 and 19 EB ALD 070. Both are on point. My case is even better concerning the Pucci case, both of which are Pucci case versus Cook County Electoral Board, 682 Northeast 2nd District, 258, 259, Illinois App 258. And Mr. Casper has played a great word game here, but nonetheless, it's so clear that it's the highest level of crystal. And in both of those cases, the objector was not a registered voter and the listed address on the objection. In one of the cases, Mr. Finko was the attorney, and he asked Hearing Officer Cologne for an evidentiary hearing. It was denied because standing, as your own now board ruling has said, as well as the Pucci case, is it's on its face. It's on its face. Say it one more time. On its face. So the hearing that Mr. Casper went through is not relevant. Moreover, the Bristol branch registration was in the 29th ward. It was in the 29th ward. But here, the hearing officers incredibly, amazingly found his testimony credible when he was left the 53rd Street address a few years back, registered at 6330 South Ingleside, one address, then re-registered at a new address, 6448 South Ingleside, says in the records, which I won't go through every quotation because I don't think I'll have time, but I did bring them. If you give me extra time, I could show you the specific sheet and line numbers. He says, I sleep every night at 6448 South Ingleside. I eat every day at 6448 South Ingleside, and I contribute to the common expenses. Now, Mr. Casper's argument is twofold. One is that the statute says you need to be a registered voter in the jurisdiction, and then also you need to be reside at the address listed on the objection. So he's saying in this case that the registration and the residency are two different things. However, that contradicts two cases, one which he was on. One is Neely, appellate court case which I cite, and Maxim, the so-called Rahm Emanuel case, which of course Mr. Casper was the attorney for Mr. Emanuel. And the greatest intent we can find is that where you register to vote is your intent of where your residency lies. So they have these hearings that I really love at my mama's house that I've registered twice against, and I made a mistake on election day when it was really early voting, which is all incredible, is nonsense. Moreover, in terms of talking about statutes, in Illinois, it's a principal statutory construction that where the legislature chooses to amend the statute after the judicial construction, the court statement of legislative intent in Marisel of O'Neill in RE 563, Northeast 2nd District, 494, 498, Illinois in 1990, the General Assembly has amended 10 ILCS 5-10-8 since Pucci, since they have not made any alteration to the language, legal border of the district or residence address, and certainly no change was made overturning Pucci as of today, and stating that those would be different addresses, e.g. PA 98-6091, effective 7/1/14, PA 100-1027, effective 1/1/19. So that idea that you could look at it separately so narrowly is wrong. Moreover, Pucci also says that the objector, even though the facts are slightly different, yes, in Pucci, in the sense that they didn't list a address at all, the holding is the same, is that you must be a registered voter on your objection. and your registration and your residence cannot be two different things, and it has to be held to the same standard as the signer of an objection. And this is a complete violation of Pucci. It's a complete violation of your already precedent and Harris and Branch, both versus Telefero in the 29th Ward. There should have been no evidentiary hearing. I only requested him for the good faith hearing, and for both reasons, he should be stricken. And I ask you to read all of our motions and exhibits. We attached about 18 attachments.
And we did.
Thank you, Your Honors.
Yes, it's very complete. Mr. Pesca?
Okay. Hope you don't count Mr. Hartman's time setting up our exhibit against us. Here, just right there's fine.
I'm going to make an objection to this exhibit, as any substantive matters are not subject to the Rule 20. The Rule 20 is or my arguments in the motion strike and dismiss are very similar to a 2-6615 argument. That means that there is no standing. Thus, if there's no standing, you don't look at the substantive part of the objection. This is misleading. It's a misdirection. It's like a magic trick.
How do you know all
Well,
that? He hasn't even said what he's putting in the
Well,
I'm going to overrule your objection because we are, I'm interested to hear as much as possible on this. This was an these were admitted in the
Yes.
underlying.
Yes, they're in the record.
Okay.
All right, thank you, Madam Chairman, members of the board. Mr. Avila talked a lot very quickly. He said a lot of words. He did not say a single word about what these cases are about. That's what this demonstrative exhibit is. This is an example of 7 petition sheets. It's just an example from candidate Ibarra's petitions. This is not an indictment of Ms. Horton. These are not her petitions. And if you look at these petitions, these are petitions from candidate Ibarra, petitions number 728.
Objection is
Can we
non-responsive to
stop?
my Rule 20, and when it's a motion
Could I
to strike and
pause
dismiss,
my
you
time
don't
while
rule
he's
with
interrupting me?
substantive. No.
If you can control the objections when you were speaking, no one interrupted you.
Because I didn't do anything objectionable.
Yeah. I'm staying away from that. I just want to hear what Mr. Casper has to say.
Thank you. These are 7 petition sheets, just an example, from Ms. Ibarra's petitions. And you may not be close enough. You're probably, even from across the room, you can tell that there is something striking about these petitions. What is they are exactly the same. Sheet 728 is an original nominating petition. Sheet 404, 468, 814, 902, 979, and 1000 are all photocopies of that sheet. So what this candidate did is she took original nominating
Objection as to
petition.
what any candidate did. There's no evidence of what a candidate did. There was no testimony as to what a candidate did.
Mr. Avila, please.
Well, now you're assuming facts. You're bringing new evidence into a Rule 20 when there was no testimony of anything a candidate did.
This is in the record.
This is what he's saying is not in the record. There's no testimony, nor evidence, no affidavits of what a candidate did.
Avila,
We all just agree that the candidate filed these nominating petitions?
But he said something
Yes.
that the candidate did affirmatively. Somebody else could have filed it for him.
My understanding is what he's saying is that the candidate filed these 7 sheets.
That's not what he's saying.
Okay, the candidate's nominating petitions contain hundreds and hundreds of photocopies that some person, whether it was the candidate or campaign manager or one of their supporters, deliberately numbered in different numbers. So what they didn't gather enough petition signatures, original ones, to satisfy the minimum threshold. At least they were not contained in there. So if you assume every sheet was completely full and every signature on every sheet was valid, they were still 3,000 signatures short of the minimum. So what they did was they took original sheets and they made photocopies of them before they numbered them. And then they wrote original numbers on this. Hundreds and hundreds of sheets. there are several sheets where there were 5, 6, 7 photocopies of the original. Some there were only one. We went through and we established every single one. So what you're talking about is this massive shortcoming in these petitions. As I said, it doesn't deal with Ms. Horton. Ms. Horton's petitions were different. Ms. Horton's petitions, the challenge to that was a traditional records examination challenge. She filed approximately 18,000 signatures. There was an objection on traditional records examination basis. We had a records examination, and she came up about 800 short. She's short. And there was none of this sort of shenanigans going on. But she came up short. That's just the way it is sometimes. And so, unlike what Mr. Avila is trying to tell you, the Daniel versus DeLay case, that does not stand for the proposition that the objector has to personally do all of the review of everything. That's not possible. The last time Mr. Hartman and I were here in front of you, we were talking about a case that involved 85,000 signatures. That's not possible for one person to get through that many signatures in a week. And so the Daniel versus DeLay case, that stands for the proposition that where no review is done, then the objection should be dismissed. In that case, the objector refused to testify, unlike in this case, about what he did or what was done to review the petitions. And the objector's lawyer said, the objector thought, I just have to file the objection and then the board will sort out whether or not it's meritorious or not. So there was admittedly no review done by anybody. That's not the case here. As you can see from this, we do not deserve great kudos for figuring this out. This did not take great sleuthing by us. It's a fairly obvious thing, especially when you look at the original petitions. They're filled in blue ink, but the photocopies are all in black. I mean, it was not particularly tough to figure this out. And with Ms. Horton's case, the same thing. The proof is in the pudding on these matters. It can't have been a shotgun objection. That was what the DeLay case was, that a shotgun objection where there was no review done should be dismissed. We don't dispute that. But here, the proof is in the pudding. We went through the records examination, and we were right. The candidates' petitions were short. They weren't even particularly close. They were 800 below. So this notion that it should be dismissed is I don't think that the Daniel case supports that finding. I think Mr. Avila mischaracterized my stipulation. My stipulation was that he didn't do all of the review. And in the Ibarra case, my client testified he didn't review the signatures because it wasn't a signature review. It was only the photocopies. The photocopies alone got that candidate below the statutory minimum. So getting on to this standing. The objector's petitions, strike that. The law regarding objector's petitions states that the objector must be a registered voter of the political division in which the candidate is nominated. You have to be a registered voter. There's no dispute that at all times the objector was a registered voter in the city of Sherwood. These candidates are seeking citywide office, so that's all that is required. The law also says that you must put your residence address on your petition. In both of instances, the objector satisfied this. We had a hearing in both cases about my client's residence. I produced him in both instances. Mr. Avila was able to ask him every question that he wanted to, and he did that at length. Both hearing officers ruled that my client's residential address is the one that's put on the objector's petition. Well, what happened was he had been living at this address. It's been his residence for several years. He was in the military. He was serving overseas in Pakistan. He worked for the State Department overseas. He came home when his mother got sick, and he moved in with her, and he's been caring for her. Then he testified that he met a girl. He started dating a girl. Not surprisingly, he stays over at his girlfriend's house. They went to early vote last year at an early voting location, not in the precinct. He testified that he went to vote. He asked the people working at the voting location, can I vote here, even though my address is somewhere else? And they said, sure, you can vote. And he said, will this change my voter registration? And he was told, no, you have to submit documentation for this. He said, well, okay, and then he never did. A couple of weeks later, he got an email notice from the board, from Mr. Holliday, saying your registration's been changed. And And he said, well, I didn't intend for that to happen, so he immediately went online that day, December the 5th, and changed it back to his real address.
So, Mr. Casper, that email, is it in the record?
It is.
Mr. Abel, you're shaking?
Well, no, there's an email that he received from the board. It doesn't say anything of what he said, and there's no corresponding evidence of what he did on what date.
I just asked if the email was in the record. Yes or no?
Well, actually, he showed me an email on my,
Yeah,
on a phone.
The email from I attached it to my response to Mr. Avila's motion to reconsider in matter number 020. It's an email from Mr. Holliday and on December the 5th of 2018, restoring Mr. Rogers' registration to the place where he thought it should be all along. Now that's an important date. December 5th is an important date because it was before this case was called the first time. It was before anybody challenged his residence. He caught that on his own and he corrected it immediately. So the question is, and so my client satisfies the legal requirements for standing and for pleading because he is a registered voter of the city of Chicago and he put his residence address. So Mr. Avila then moved on and started questioning whether or not he lived there at that address. And as I point out in my response to the Rule 20, residency is a fact-by-fact, a case-by-case factual determination. The appellate court has determined that. In this case, both Mr. Assingen and Mr. Ponsetto conducted evidentiary hearings and they took evidence on this question. Mr. Ashenden said, objector credibly established his residency at 1229 East 53rd Street. In addition to his testimony explaining long-term residency on 53rd Street, his mother's house, he tendered current valid driver's license with that address, provided copies of the important mail he received there, and testified that only junk mail goes to his girlfriend's address on South Ingleside. His testimony, the explanation of his Gerhardt name, and the proofs tendered were credible. Objector explained his voter registration change and goes on to explain his finding. And Mr. Ponsetto similarly said at an evidentiary hearing, he testified about why his voter registration was wrong when he went to the early voting site. He did not lie and listed his address to where he was registered. Importantly, Mr. Ponsetto also noted that the candidate called no witnesses and offered no traditional residency documents for any other address. And so, because it's a case-by-case basis, the hearing officers made that determination. Mr. Avila cites two other cases from the board regarding Alderman Talafaro. In both of those cases, however, the hearing officers made the opposite conclusion. In Branch versus Talafaro, the hearing officer found, quote, the objector's petition should be stricken in whole because he does not reside at the address stated in his petition, and therefore he has no standing to bring his petition. In the Harris case, the hearing officer found the objector's petition should be stricken in whole because he does not reside at the address stated in his petition. So they're they're case-by-case factual determination. Each hearing officer makes their own determination. The Neely case is important because that stands for the proposition that voting is an exercise or an example of residency, which it is. But in Neely, the court went on to explain that the candidate who voted out of the ward in which he tried to run, did not offer any evidence that that vote was by error or mistake. Here, the objector testified credibly to both hearing officers that his registration was moved without his knowledge and through the error or mistake that the Neely court contemplates. The Pochi case is not on point, has nothing to do with this. This simply says that you have to, Pochi stands for the proposition the objector has to state, you have to write their address on the petition. There's no challenge, there's no suggestion that the objector didn't write the address on 59th Street completely on the petition. So that's not relevant here. And finally, the case that this is most like is Henderson versus Miller, a case where a candidate for alderman moved and forgot to change his voter registration. So he lived at one address, but he was registered at another, and the appellate court said he was qualified to be on the ballot. And for that reason, that's very, very similar here. This case is even better because the registration was changed without the objector's knowledge or consent. And in that case, it was the candidate's inadvertence, but the court still said it was sufficient.
So I just want to clarify this last one.
Yeah.
Excuse me. So what you're saying is that for the purposes of objection, registration and residence do not need to be one and the same?
Correct, yeah. That for purposes of being an objector, there are two requirements. To be an objector, one, you have to be a registered voter of the political union. No dispute that the objector is here. Two, you have to put your residence address on the objector's petition. And that's what the fight was about here. Both hearing officers found that it was, which is exactly the same as Henderson versus Miller. In contrast, and a good example for that is regarding the ability to sign a nominating petition. Yeah, like these folks up on this sheet, and at least on the first one of them, the non-photocopy. In order for your signature to count on this petition, you have to be a registered voter at this address. So it has to be the same. Why is that? Because section 3-1.2 says they have to be the same. So there is a different standard for petition signing. There is no corresponding provision like 3-1.2 for objectors. It's a lot more like Henderson versus Miller, where you don't, as long as you're a resident of the ward, or in that case, in the ward, and registered to vote in that area, I'm answering a question, then it's sufficient.
So had Mr. Rogers conducted grace period registration or early voting in Matson, his girlfriend lived there, he'd be talking this scenario, correct?
Correct. I agree.
Mr. Casper, I guess the question is how much does the objector have to know about the petition that he is filing? This is one of the issues Mr. Avila has brought up.
Yeah, I think that, you know, that's a good question, and I'm not sure that we've gotten a lot of direction from the appellate court. What the case that Mr. Avila cites stands for the problem. When no review is done, then, and it's a shotgun objection, then that should be dismissed. I don't think anybody disputes that. The Nader case stands for the proposition that the Electoral Board can't really do an inquiry into how the objection was put together. So somewhere it's in between. In like the case involving Governor Quinn's referendum petition, it's not possible for one person to do it all. I was involved in a case a few years ago at the State Board that involved 500,000 signatures. I mean, it's just not humanly possible for one person to do it. So I think that there's no requirement that the objector be the one to personally do it. And in this case, the objector's knowledge base was not elaborated much in the record because it was privileged, because it was a conversation with me. And, you know, that's what they hired me for. So I think that the real important point to think about these questions is whether or not the proof is in the pudding. Right? In this case, Ms. Horton, unfortunately, she put in the petitions and they were just short. She was short about 800. In the other case, I mean, this petition would not have survived the apparent conformity review, I don't believe.
You know, my experience is it's quite common for objectors to hire attorneys to prepare objections. And I feel like, to a great degree, the mere act of hiring a licensed and experienced attorney to do something on your behalf is inherently good faith. So if there were to be evidence shown that the attorney or the law firm and the team that attorney uses acted in bad faith, and so therefore the attorney and law firm made essentially a false representation to the client who's going to sign off as the objector, then that's one thing. But I do think that, you know, objectors are acting in good faith when they hire an attorney to prepare an objection for them. And I think that in this case, it's clear that the law firm did do an investigation, and then in good faith gave a summary. Even the candidate in this case has admitted in pleadings and whatnot that there have been in the testimony cited by Mr. Avila today. They're showing summaries, they're explaining summaries as to what was involved. And faith, absent any evidence, and this case is absent of evidence, that the underlying law firm did not actually conduct a review.
May I respond to that, please?
Yeah, briefly, yes.
Yes. Well, where is the statute or case law that Mr. Lasker is citing that hiring a licensed attorney means inherent good faith? There is none. His opinion is interesting. It may even have merit, but it's not based in statute or case law.
Well, let me ask you this, where do you find this in statute or case law the opposite?
Well, I'm glad that you asked me. I already had cited to it, but I'll cite it to you again, Your Honor.
It's the law, it's the oath of office attorneys take.
Well, but the attorney is not the objector.
Well,
Then,
I'd like to hear his response.
first of all, you have here from your own board, and then I'll cite directly from the case. Here it says, when an objector's petition is not prepared as well as a reasonable inquiry investigation of the facts was not made in good faith, the candidate's motion to strike and dismiss the objector's petition should be granted. In Prince v. Colvin, 08 EBRGA 33, CBC, December 7, 2007, and Young Curtis v. Wild, 03 EBALD 139, CBC, January 31st, 2003, finding it proper to dismiss an objector's petition when it's not made in a reasonable inquiry and investigation of the facts that were not made in good faith. Hiring an attorney is not an act of good faith.
Which rule is that, please, just for the record?
it's a case.
It's two cases, I say.
Oh, okay.
Okay.
And
Now,
it's
in
also
terms of the
codified.
appellate case,
Well, and Mr. Avila, I understand that, but I haven't seen any evidence here that, there wasn't some kind of reasonable inquiry made, or that the objections were not made, in good faith. Shotgun objections, for example, that, we have upheld, as not being in good faith. I just don't see, the connection between your argument and what the evidence is here. And I'm looking actually at the acknowledgement, on the verifications on these objections, where it says, I, Daniel David Gerhard Rogers, being first duly sworn upon oath, depose and state that I have read the above in foregoing objector's petition, and that the matters and facts contained therein are true and correct to the best of my knowledge and belief. I don't see, how, this can be said to be in this, based on what I've read in the transcript and, the exhibits I've seen, how this has been, according to you, bad faith.
well,
I just
I'd be
don't-
happy to respond to you. Okay? First of all, he says he doesn't know what the recapitulation sheets are. In the objection which he signed, that's a very good question. Mr. Casper is not the objector. Mr. Casper did not sign the verification. And signing the verification is the exact person that Daley talks about. And when you sign a verification, he's saying he has knowledge of the objection. When I ask him in the
No, he's saying he has read the above and foregoing objector's petition, and that the matters and facts contained therein are true and correct to the best of his knowledge and belief.
but he has no knowledge.
No,
Well, if you could let me answer, I could cite you from the record.
I've read
Well-
the record, but I mean, you have securities litigation, for example, very complex, where, a plaintiff files a complaint, and a verified complaint, and I don't expect my client, a plaintiff, to understand every single assertion made in that complaint. But it is filed in good faith. That's the role of the attorneys, to go through everything and make the proper allegations in the complaint, the proper objections. I cannot rely on my client to do that.
Well, I mean, that's a very good point. So I want to point to you, page 30 in the transcripts on the case of Arias Ibarra. Yes, Arias Ibarra. I asked him, who asked you to be the objector in the case? And he answered, I have a friend who works for the clerk who I met in grad school, is heavy into politics. Question. And they said, hey, could you stick your name on this objection? And they said, yes. So there's no evidence that he hired Mr. Casper. There's no evidence he knew anything about the objection. So I agree that you don't have to know everything about every piece of case law, but you should have some basic knowledge of the facts. And this is not complicated securities. If you sign that the recapitulation sheets attach certain sheeted line numbers, you should know what the recapitulation sheet, appendix recapitulation sheets are. In his answer, when I said, did you prepare the appendix recapitulation sheets of Patricia Horton? He doesn't say, well, my attorney did. He says, I'm not sure what that is. So that tells me he doesn't have knowledge of it.
Well, I think that.
And also, if you look at Daly, that's direct contradiction of both what Mr. Casper and you are saying, because one of the issues here is, one of the issues that is here in the appellate court case, hold on, I'll get to it. Issue of whether Electoral Board's dismissal objections to nominating papers of potential candidate the Community College Boards of Trustees was arbitrary and contrary to law because Electoral Board's sole basis for dismissing objections was the objector did not personally conduct a record exam before filing his objections to act as the election code did not require him to do so and would subject to de novo appellate court. Now, in this case, this is an appellate court case, and it holds for two things. That if you verify the petition, you have to have some knowledge of the petition. The objector does, not the attorney. The second thing, which was a fact, the same facts, in the case of Daniel V. Daly, that objector never reviewed any records. That's the same in this case. And he said he saw a summary. When I asked what the summary was about, he didn't know. He said he saw a box. I go back to the question. He didn't hire Mr. Casper. A question, and they said, hey, could you stick your name on this objection? And he said, yes.
I think I understand your argument. I think based on what you're reading in the transcript, there's a jump there between what you're reading and the facts, some facts that you're assuming.
I don't know what that is, Your Honor. That's a direct answer that he answered yes to. I'll tell you one more. Mr. Casper, it's a stipulation. I'm willing to stipulate that my client didn't do it. Anything regarding to the petition, that was the question. And then Mr. Casper said, we'll stipulate that he didn't do the work. Then another stipulation, we'll stipulate that he didn't go examine my question, did you ever go to the Board of Elections to look at the documents? And then he said he did not, and we pulled the records and we provided those records. Same exact thing in Daly. And I said, did you ever look at the petitions of Patricia Horton? And then Mr. Casper stipulates that he didn't look at the petitions or any documents. That is Daly. Daly had an attorney, by the way. The objector had an attorney. So the idea that hiring a licensed attorney is in error of good faith, the opinion of your board counsel goes in direct contrast to an appellate court controlling case from this district.
Thank you, Mr. Avila.
Briefly,
Just briefly.
Supreme Court Rule 137 imposes an obligation on me, Mr. Hartman, not to present arguments that we do not believe are meritorious and have been made in good faith. Supreme Court Rule 137. And I stipulated that my client didn't do the legwork, so to speak. Right, that's what he retained me to do. And the people who did it under my direction. That's what you hire lawyers to do. So I think he's grossly misstating the holding of Daniel versus DeLay, which the point of which is there was no review done. That is not the case.
One more board precedent I want to cite that you have here. You had a case that was dismissed by a hearing officer in the case of LaShawn Ford candidate. And in that case, the documents from the board indicated an approximately 80% signature line sustained, not sustained of all objections. That means that 8 out of 10 signatures were sustained, which would indicate there was effort into that. But you found there were some photocopies of, don't know how many, there was no testimony, but there were some photocopies. So even though the sampling showed an 80% signature line sustained, it means 8 out of 10 signatures of that candidate were bad, that candidate still received a motion to strike and dismiss, even though clearly the objection had merit. So the merit of the objection is not the basis of the motion to strike and dismiss. And I'm not making an extension at all. I'm citing directly from the record. And when I did try to get into it, Mr. Casper would object, or the hearing officer would not let me go further. And it was very clear that this objector did not know anything. And if we're going to violate an appellate court case on people's opinions or an interpretation of a record, not actually what the record says, that's a very dangerous road to go down.
Thank you, Mr. Arnold. If there's no further comments or questions, I would entertain a motion to
Your Honor, I would like to respond to his part on Pucci. It's my emotional 20, actually,
Well,
with the
I
last
think
word.
you have stated sufficiently on Pochi and in both in writing and verbally.
Yes, Your Honor,
Yeah.
as you wish.
And you have cited it, and you have preserved any arguments you may have on them. Is there a motion to deny the Rule 20s in 19 EB-MUN-014 and 19 EB-MUN-020 adopt the hearing officer's report and recommendations in each of those cases? Is this a final decision? And enter final decisions in each of these cases, adopting the hearing officer's report.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The Rule 20 is denied in both of these cases, and the motions to adopt the hearing officer's respective reports in the aforementioned cases is granted, and it's therefore ordered that the names of the respective candidates shall not be printed on the ballot for the general municipal election. And we will give you copies right now of those written decisions.
To these parties and to all the parties in the room, when the final decisions are entered today, the Electoral Board will be signing them here in open session as they are with these two cases. They will then be depositing those decisions in the mail pursuant to section 10-10.1 of the Illinois Election Code. You then have 5 days to seek judicial review. For any party who would like to stick around until after the hearing, we can give you a copy of that final decision and serve it on you in person today, so that you don't have to wait for it to come in the mail. But otherwise, and either way, the clock will start today, because we will be placing them in the mail today unless you stay. Thank you.
Thank you.
will recall, Brenda Hardy versus Gayinga, Washington, 19 EBALD-005, candidate for the alderman of the 29th Ward. Gayinga, Washington is not answering.
Madam Chair, for this particular Rule 20, I would like to suggest that we just deny it. It actually is deficient in terms of the rule. It did not state any of the reasons for which she wanted to present additional argument what the topics or issues would be. I was going to suggest a summary dismissal of the motion, but since she was pro se in the hearings, I figured we'd give her the benefit of the doubt. But the time is now 4:23. This agenda was posted, pardon? 4:32, excuse me, for an electoral board meeting that was noticed to begin at 3:30. So we waited an hour now.
Is there a motion to deny the Rule 20 motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. And we have,
No objections?
No objection. Thank you.
Thank you.
is there a motion to sustain the objections of Bruce Washington against Gayinga, Washington in 1980-001? Is this a final?
It is, the other case is also, the companion case is also on the agenda for final decision today, both with the same outcome.
Well, I don't really, is there a motion to sustain the objections and adopt the hearing officer's recommendations and report?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes.
Yes, bro. Yeah. Great. With the 19 EBALD 1 and 19 EBALD 1.
Here are final decisions.
I just want to make sure that that was for both cases.
It was, numbers 1 and 2 on the agenda.
Under part of that.
Part up, yeah.
And number one under part two.
We have one more, which one?
Two more. Number five and number
Sure.
50.
The next one is, we will recall Renee G. Elms, Peter Rivera, Renee Rosiak, Maria Orihel, and Evelyn Razo, versus,
Pardon me. Would you mind if we switch the order
no,
of the cases?
I don't.
Okay.
So which one do you have? I just want to make sure.
Hmm?
Which one do you have?
It's the Jeanette Taylor one after.
Kevin Bailey versus Jeanette Taylor. Kevin
Yes.
Bailey versus Jeanette Taylor.
Okay.
150.
Then we will proceed with Kevin Bailey versus Jeanette Taylor, 19B-ALD-150, candidate for the 20th Ward. Is there anyone here? Is Jeanette Taylor here?
Jeanette Taylor is here, yes.
Thank you.
And you represented by counsel?
Ed Mullen on behalf of Jeanette Taylor. And Mr. Bailey is not here.
Okay, and this is Rule 20?
Mr. Bailey's.
Mr. Bailey. Okay, well, it is 4:36, and this is the second time this matter has been called. The objector is not present. Is there a motion to deny the Rule 20 motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. And is this final?
Yes.
to, in Kevin Bailey versus Jeanette Taylor, 19 EBALD-150, to adopt the hearing officer's recommendation and report.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the name of Jeanette B. Taylor shall be printed on the ballot for the municipal general election.
Thank you.
And now we will call. I think we still have the second one, right?
Correct.
I'm just looking for. I'm just looking for the what number is that in
Two under B, these were.
we will recall Renee G. Elms, Peter Rivera, Renee Wozniak, Maria Orihel, and Evelyn Razo versus Joseph G. Williams, 19 EBALD-105, candidate for the 15th ward. Are any of the parties here?
Scott Erdman, stepping up on behalf of James Pinelli, who's the attorney of record, and also prepared.
You're,
I'm the attorney and tree killer on behalf of the
on behalf of the objector?
Yes. And this is your Rule 20 motion?
Yes, it is.
And the candidate is not here, Mr. Williams. Okay. Well, Mr. Irvin, why don't you proceed?
Okay.
And again, I remind you of 10 minutes. I'll stop it while you're.
Thank you.
Okay.
Okay,
I'm ready when you are.
okay, go right ahead.
So the allegation in this objection was that Mr. Williams circulated petitions prior to the first date that he did himself, and that he did it at the weekend prior to August 28th at a neighborhood picnic. We have two witnesses, Mr. Kresse and Mr. McCann, who gave direct testimony that they were approached by the candidate, and he asked them to sign his petition, and they refused. The candidate testified that his wife picked up the petitions at Progress Printing after work on the 28th, and then he started circulating. And he specifically testified that each and every signature and on each and every sheet was the product of his walking door to door to circulate the petition and gather signatures. Well, it's just,
Can I
yes.
ask a question? 'Cause according to the hearing officer's reported recommendation, he says about Keith Kresse and Freddie McDaniel, both witnesses testified that the candidate circulated his petition sheets at a barbecue. They didn't, the hearing officer doesn't say that they were asked to
The
sign.
Rule 20 motion does.
The Rule 20 motion does, but
What I would say is the fact that it didn't make it into the hearing officer's report doesn't mean that it didn't happen. And Mr.
Well, that's what I'm
Nally, who was
asking.
present, prepared that. So it becomes a question of credibility that Mr. Williams says, no, I didn't get any early, I got them all on the 28th and the 29th, and picked up the petition at Progress Printing and then hit the streets. So just his alone, if we look at it, the exhibit contains pages 1, 2, 3, 4, 5, 6, 7, and 8. And a simple,
Look at the first one you gave?
yes.
Okay.
So sheet 1, you look at it and it's got, one of the functions on Google Maps is that you can put in walking times. And I put in the walking times from each of these addresses to the next one. And the first sheet was a mile and it took 5 minutes. The second sheet was 10.8 miles and took 215 minutes. Now the interesting thing about that is that going door to door,
I'm sorry, can you state that again? I missed
on sheet 2, we went 10.8 miles and took 215 minutes. That's just the walking.
to go from address to address.
Correct. And in the middle of these, he went from 5810 South Laughlin Street to 5930 South Michigan. A detour of 45 minutes walking and 2.2 miles. Then he went back into his, to get a out-of-district signature, by the way. Then he went back into his district, taking an hour and 3 minutes and walking 3.1 miles to get to 6334 Winchester. Then he took 13 minutes to go 0.6 miles to another address. Then he took 12 minutes to go 0.6 miles to another address. Then he took 14 minutes to go 0.7 miles to another address. So line 2 shows 10.8 miles, 215 minutes. That doesn't even allow the door time, the face-to-face time that would have accompanied actually gathering those signatures. Go as fast as I can here, so. Sheet 3, 4.2 miles, 83 minutes. Sheet 4, 9.2 miles and 185 minutes. And in the middle of that, he walks an hour and 9 minutes out of his way to get an out-of-district signature, and then walks back an hour to get back to where he was, it was in his district. And the signature was an out-of-district signature. Sheet 5, 5.8 miles, 115 minutes. And in the middle of this one, he walks 1.9 miles out of his way for 37 minutes to get a signature, and then walks 31 minutes and a mile and a half back to get these signatures.
And you're basing that on the testimony that said they walked door to door?
Yes, he was adamant about the fact that he went door to door and he got all of these, and he actually sat down with one of the signers and had lemonade in their house, which isn't included in this time. So, sheet 6, 3.3 miles, 64 minutes. Sheet 7, 13.8 miles, 277 minutes. And in the middle of it, he walks an hour and 40 minutes, 5 miles out of his way to get a signature that's out of his district.
And was this presented to the hearing officer?
The sheets are, they're in evidence, and the testimony was that there was no way that he could have the objector's position was that there was no way that he could have gotten all of these signatures on the time period that he did, on the 28th and the
I understand,
29th.
but is this particular,
This-
particular evidence
No,
used to teach the credibility of the witness?
this is merely the step-by-step from point A to point B that he says that he's making. We're rebutting what he said, and his testimony was, I went door to door.
With respect to the premise is not the same, but the evidence to back up the premise is new, or presented for the first time.
Yes.
Has the hearing officer seen the Google Maps stuff?
No,
And heard these specific times calculated by Google?
no. But I do want to make the
Allowing
obs-
the record to be expanded?
That's not
Because
what
Rule
I'm-
20 says that we,
that the board can hear.
the board has the discretion to, but there's been no actual request made.
Does the candidate object to this evidence?
Well, the candidate-
It's not
Therefore,
Is this candidate represented by counsel? Somebody found parents on behalf of the candidate?
The counter, he was pro se.
Pro se. But the candidate was given notice of
He
the
was,
Rule
it's fine.
20 and should have appeared here. Um, And the August 28th was the first day.
Second day.
Was it the first or second day?
First.
First day.
so these Google Map information is merely this chart's merely a summarization of evidence that was put into the record previously.
Right, it's a summary. You could consider some kind of summary.
Yeah, correct. So for number 7, his testimony was that he walked from the house on sheet 1 to the house on sheet 2 to get it.
Yeah, it does summarize, I don't know, I think in some ways the timing is new evidence. Because this,
And-
hypothetically, he could have sprinted from door to door. We don't know,
And
unless that was in the record.
And had he appeared on his own behalf, in this case where his testimony was central to the hearing officer's decision, then he would have been able to counter that, and he would have been able to tell me how fast he was. But these are, Google's Maps wants to tell people, get off the bus here, you're gonna walk 5 minutes over to the next bus, and you're gonna catch that bus. So their interest is an accurate amount of time that the average person walks to get from point A to point B, so they don't miss that bus.
And
So if we
what
wanna-
presumption Google's right? What would be the presumption that Google's right? I know we're presuming it, but Google let
Yeah.
it straight many a times.
Well, but there is no objection.
I understand.
I would think that we could take this information into consideration to the extent that it summarizes information that was previously in the record. We don't need to take further conclusions from it than that.
That's a question.
Yes.
Mr. Urban, did the candidate who is the named circulator on these sheets, did he testify that, yes, indeed, these sheets that bear a notarization date of August 28th, that there was no error in that? Did he
No, that he was adamant that they went out, they hit the road, his wife picked up the sheet from Progress Praying because they wanted the Union Bug, and they hit the streets and went out and circulated. He circulated personally on the 28th, and I believe his wife and him circulated on the 29th, but we're looking at the 28th and the 29th, based on the sheer volume of signatures that this candidate is telling us, that he went out on foot, door to door, and gathered.
If we deduct those sheets from the 28th, would the candidate still have the requisite number?
I don't believe so.
And there is the other allegation here about the barbecue, the August 19, 2018 barbecue.
Correct. So
are those segregated somehow?
No,
No?
the allegation is that he circulated sheets prior to the first date that he could legally do so. There was testimony from two witnesses that said he did it at the barbecue. The hearing officer said, I don't find them credible, I find Mr. Williams credible. Okay, and what I am saying is, based on the facts of what Mr. Williams said he did, it's not credible because of the amount of time it would have taken him to do it.
But those would have been the petitions that he submitted on August, that he notarized on August 28th. What I found compelling about what the hearing officer said was the fact that if you look at the addresses, they're all in the type of order where you would go from house to house. So in a barbecue where there's 1,000 people, how would you have that? So I tend to agree with the.
Well, and my point would be, let's look at what he said he did, and tell me why he went 5 miles out of his way while he's walking down the street to go get another signature, okay, out of his district. Well, that doesn't happen when you're walking door to door with your sheets. That happens when you're at a barbecue and somebody walks up to you to sign your sheet and they live outside of the district. Now, the barbecue was a neighborhood barbecue where everybody lived in that area.
I don't know about that.
Or-
In transient areas, especially lower income areas, people move around a lot, from apartment to apartment. And so, you know, it very well be, the question could be asked hypothetically, hey, where are you registered? And it could have done that. I mean, so I don't necessarily buy this.
It's not a question of buying it, it's what the question is.
Well, in this case, it's about persuading us, so it is about buying.
Is he testifying? This is what I did.
Well, it could also be.
That every single one of them, he was adamant about the testimony, and testimony as to, I went into a house and had lemonade with one of these people, I went door to door.
I realize that, but if the second signature, the person who lives 5 miles away, if they're over at the first person's apartment just visiting,
Okay.
playing Parcheesi, they would
Then-
sign this.
I've also circulated petitions door to door, where you're getting every signature you can, so when you happen to just see someone walking down the street, you stop and say, excuse me,
It
do you
could be
live in this
that is-
ward?
Yeah.
And that random person you see on the sidewalk, you're not gonna just let them go just because you're
There's
going
no
door to door.
requirement that they have to sign at
At
their
their
own
door.
particular residence.
Right.
Yeah. Or at their door, yeah.
Okay, so let's back the time out of this and look at what he did door to door then. And it still is more hours than he says he had. I anticipated this argument, okay? If we back that time out, okay, for these outliers, okay, and some of them are outliers and some of them are him literally just going door to door, 4 blocks, 5 blocks, 6 blocks, 8 blocks out of his way to get the next signature. Take that out, take the amount of time that he said he was walking, add in, you know, a minute per signature, and he just doesn't have the time to do it.
Madam
And,
Chair,
the second date, the 29th, is even worse.
Madam Chair, just to point out, the candidate filed 95 sheets. So you were asking for either of these packets were eliminated.
My feeling on this is if we could defer this decision to our next meeting, unless,
Defer to.
for further consideration based on,
Further review of the record.
yes.
And the fact that the pro se party was not here.
Are you, you would need to make a motion to
I-
admit?
I would make 2 motions. One, the candidate appeared pro se. The candidate defended himself, knew that his testimony was central to this decision. That it was a case of who's credible, and the hearing officer said, you're credible. Okay, we're here to rebut that. He knew that. He isn't here. So my first motion would be that he should be defaulted because he's not here, and I will, I will appoint you granted. Okay. I'd want to know what we're recessing for, and what do I do? You know, what happens next for the objector?
That's just one opinion.
I'm not fighting it, I'm just asking, you know, are we gonna reconvene and continue arguments and hope that he's here?
Well, whether or not he's here, this is your, Rule 20. Whether he's here or not, I think you have, you want to carry this Rule 20, and I don't think it's, the type of situation where we can default the candidate.
Yeah, I'm of the opinion that I see this, I see the substance of what's being listed here, very ingenious, I must say, but the substance of what's being listed here is in the record, but the time side of it, you know, it's not there. And so we're gonna, if you want us to introduce and consider this time argument that you're making, you know, I'd want more time to look at it, and you know, and I obviously would love to have a candidate here to be able to ask questions. But in all fairness, and because he is pro se, I think, you know, there is a level of liberty that we do give to pro se litigants. But that's my thought.
Counsel?
Can
Can I ask our general counsel a question? How many signatures were required for this race?
475?
473. There was also a records exam conducted in this case that resulted in showing that the candidate has 83 signatures above the minimum. I don't know how many of those signatures would still be at play in these sheets 1 through 35. But it's
Sufficient.
probably more than 83. Yeah.
And if we're gonna go reconsider this, I do want to point out a couple of things for you to put in there. If you, on the first day, the testimony was that his wife picked up the sheets afterward. There's no testimony as to what time his wife got.
Correct.
Progress printing opens at 9 a.m. Called them today. We're open at 9 to 5. You know, every day we're open. So, assuming she got there at 9, okay, you guys can think of a reasonable hour of the night that you wouldn't be knocking on people's doors asking for signatures, okay? 9 o'clock, to be generous. I don't think people are gonna be knocking on doors. So you've got the largest window possible is 12 hours to get this done. And based on him walking around, there isn't enough time. Then if you look at the second day, where he went 99 miles, 99.9 miles. Throw out the outliers, that's fine. Before the outliers, 35 hours, 8 minutes. That means we'd have to throw out 11 hours, 8 minutes, just to get him to 24 hours worth of circulating. Okay, and that time doesn't include, like I said, the door-to-door FaceTime. For these sheets, 15, just these sheets, not all the way up to 30, 35. This is as far as we got. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 13 sheets. Just walk time was 35 hours. Not FaceTime, and between each of these sheets, I gave Mr. Williams the benefit of the doubt. I didn't go from page 1, last address, to page 2, first address, because I can't make that assumption that he did that. So I kept it to the sheet. So he started at line 1 and he finished at line 15. So there's no FaceTime, there's no going from whatever order these, sheets were. I wouldn't expect them to say, that they were any certain order, but we just know that it's impossible probably to say. They all landed on the kitchen table, we put them together. So I didn't make that assumption. So just looking at the math, there is not time for this candidate to do what he said he did. And if you then go back to what the hearing officer ruled on, he ruled on the credibility of the candidate versus these two people who testified that they were approached at the barbecue before the 28th, which was the first day to legally circulate. And if you then just credit the candidate, which 35 hours at the very minimum in a 24-hour day, assuming that he was circulating it, 12:01 a.m. to 11:59 p.m., it just doesn't add up. You can't do it.
Was there any testimony about what kind of barbecue this was?
It was a neighborhood barbecue. It is the Hermitage Park barbecue, so it was from that area.
And where's Hermitage Park?
Pardon?
Where's Hermitage Park, do you know? Or setting the record?
I don't know, and I don't know if it's in the record. But the number of sheets or signatures from Hermitage puts it in the center. That is, I think is what the other.
And this, as I remember the record, this is an annual event?
I have to say I'm weak on the barbecue information. I don't know if it's annual or not.
But it was sponsored by the candidate?
Not to my knowledge.
It wasn't in the record?
We don't have the menu either.
My questions weren't about
Yeah.
to that.
But
My
who
questions are
brought these people there?
because he's presenting an argument about the ability to circulate in a particular area, and if this is from the neighborhood, I mean, there's arguments on both sides on how it can play out. So I just want to give more information to as we reconsider to see what impact. If he lives in the precinct, he could get signatures quicker potentially if he knows everyone in the precinct. Who knows? I mean, there's evidence on both sides. I just want to give more facts.
Well, we went off of what his testimony was, and that he walked from door to door to get these signatures, and that he visited all of these addresses. Okay. Again, throw out the outliers. That's fine. There still isn't humanly possible. There could be other alternate explanations, but to do what he says he did, that would be everybody come outside and meet me on the corner. Everybody from these 3 blocks, because I'm collecting signatures, meet me on the corner and that's where I'll get them. That wasn't his testimony. His testimony was, I went door to door. And this is how much time it takes to go door to door.
Mr. Lesko?
So, one of the things that's confounded me here is that the hearing officer's report is really heavily focused on what he calls the 2 early affidavits and the barbecue. And all this information that we've been provided today, which only some of it was actually provided to the hearing officer, is pretty compelling, right? I mean, it's pretty compelling that in 12 hours, looking at these notarization dates, all right, so it all happened on that one day. Well, how much of this was actually presented below, and how much of it is related to the objector's petition? Because paragraphs 7 and 8 are what the hearing officers are saying are an issue. One being that the people signed too early. My concern here is that, is this evidence related to the objector's petition that people signed too early? Or is this evidence that the notarization dates are fraudulent or incorrect? Because this is the first day of circulation. I mean, he clearly could have circulated these sheets for several weeks. It's not what he testified. I hear that.
And part and parcel of you couldn't have done this on the 28th is that you did it prior to the 28th. And that you couldn't have done this on the 29th.
Or after.
You did it prior.
So the problem is objector's petitions have to be ruled upon for what's actually stated in them, in the actual objections lodged. So I want to, pull up the objector's petition, because if the only allegation is certain sheets are improper because they were circulated too early, this is not necessarily as compelling evidence as we might think, because it might be that even if the candidate lied about it, it could be that under the testimony, it could be that these were circulated after the 28th. In which case, it wouldn't answer to the objection that's actually in the objector's petition, that they're alleged to have been signed too early.
And the notary either mistakenly or
it could have been, yes, it could have been a
dated it
notary
wrong.
mistake to put down the dates, and then when presented with the sheets on the stand, I don't know, the candidate's not here to answer. But it could be that the candidate testified that he circulated these on the 28th, because that's the date that the notary put down. And he may have thought, well, I must have circulated, I don't know.
In response
Yeah, but
to
you
this
presume,
allegation.
hold on, counsel, but you presume that there's a presumption that the notary is accurate, correct?
Absolutely.
There's nothing in the record that says the notary is inaccurate.
Absolutely.
So from that, you have to presume that on the 28th, all of these were signed. You have to presume that.
Yeah.
And the argument being made is that time does not allow for that to be true. Therefore, it logically follows that they were done at some point in time before the 28th, because you presume it's correct. So I'm trying to understand how you're getting to the question that they could have been done after if we have to presume this is correct.
Well, you're right. There would have to be
Some evidence.
testimony or evidence that the date, the notarization date's wrong.
And
Right. And
Which
honestly,
could have been a good response
and
by
very
the
honest,
candidate, but it wasn't.
and honestly, the one on the 29th was probably a bit more, less compelling, because technically you had 2 days to do it, right? This one, the 28th is really the one that has the impact, at least in my mind.
And if you add them all up and look at the amount of time on both days that he could have done this, it compounds it.
And there's 2 sheets in here for the wife?
The wife did, the hearing officer's recommendation states that there were 2, but there were actually 5.
5 for the wife?
Yes,
Circulated by his wife?
correct. On the 9th, on the 29th.
2020,
But-
or signed on the 29th? Right.
But what happens is, the allegation is made, the hearing officer has denied the allegation because he found that the candidate was more credible than the 2 witnesses who came in and under oath said, I was at the table, I was asked to sign the petitions, and I refused to. He took judicial notice of how close the houses are together. But what he needs to take judicial notice of is the fact that it's impossible for him to do what he said he did, and therefore his credibility is gone.
Mr. Marisel, I'll throw it back to you.
Oh, I have one more question.
Oh, I'm sorry.
So if we're going to consider this, I want to go back to my question. How do we know Google was right in terms of how long it takes? Because your argument is based on Google. And so what is that based on?
I can't give you expert testimony as to Google, but I do know that their business plan relies on their data being up to date and constantly being gathered and updated. And all of the apps that people use, the CTA apps, the train, they use that same GPS data that is produced by Google. CTA uses it, and they have to be accurate because people, the bad weather's coming. If Google tells me it takes 4 minutes to get to the bus that I have to catch, and it takes 8, then their business model collapses, and there's billions of dollars that say that their business model is.
So hold on 1 second, Bill.
Sure, no problem.
But let me push at that for a second. I hear your point in terms of where locations are and distance between locations, but I could probably tell you that if me and Lance walk the same distance, he'd probably beat me, just because of how Lance is, right? His legs are longer, that might get me there. So I guess what I'm trying to get to, how do we determine that the time is accurate? Is there anything you have that you can enter into the record that says that the Google time, when you say here, it takes 10 minutes or 15 minutes, that's based in something?
Again, a business model that is based on constantly being right with their information. They can't run, they're not worth, Mr. Bezos isn't worth $130 billion.
Yeah, I don't think that's relevant. I'm asking a question about 2 human beings and their time to walk from one place to another. We're not talking about a bus, we're not talking about a car, we're talking about walking. And so I'm just trying to understand, how do we get to that time being walked?
It's an average, and even if you walked a little faster, he didn't get 35 hours worth of walk time. If we want to look at it like that, we can say, okay, he started at 8 o'clock in the morning. We'll try to get that, people while they're at home before they went to work. Walked all day. Okay, stopped at 9. 12 hours. We're talking about a 12-hour window to get these signatures. that's not 35 hours.
It's close to a 20-minute mile average.
I can tell you one thing, I just, went to Google Maps and entered my home address and entered the train station near my house, and it says it's a 20-minute walk. I walk faster than Lance, and I routinely do it in 17 minutes. So,
Well, I
so
think
this is within
you
the
get the
ballpark.
medal.
I would say that regardless of what the court's decision was, there absolutely has to be a contest between Adam and Lance. To walk from the house to
I think,
the trip.
I concur.
and then maybe a
But I have
handball.
I have a problem with.
I didn't say
You're
about
gonna have extra weight on the hand, yes.
Council,
But-
council, general council. Okay, for example, these first 8 pages that are dated on the 28th, okay? If these pages were circulated on, say, the 28th, 29th, 30th, 31st, they bring it to the notary and they write down 8/28. Then we'd have a situation where the signatures were collected post 8/28, or 8/28 and beyond, but the notarization was wrong. In the objection, is one of the objections that the notarizations are wrong?
I do not believe so.
No, but here's the answer to that. If we're gonna hypothesize that there was circulator and candidate notarization misconduct, then you can hypothesize that there's a pattern of fraud here that you cannot turn a blind eye to. So we wanna hypothesize our way out of this by saying, well, what if they were all done afterwards and they were notarized for the 28th and the 29th? Well, guess what? That's fraud.
Well, the problem here is that the candidate testified that he did indeed circulate these all in 28. That's his testimony. He
And-
could have said, oh, no, it took me 7 days, and I don't know why that date's there. The notary must have put down the wrong date. If that was what his testimony was, then it would be a much different
And
situation.
he was adamant because he wanted to rebut the claim that the reason he had so many was because he started early. So he was adamant about that they were all done on those 2 days so that he could rebut this early circulating allegation. Testified to of the 2 people who were at the barbecue. I don't know if it was wet or dry.
I'm comfortable
I guess
deferring.
you're comfortable with what?
I'm comfortable deferring to our next meeting.
Well, the question, I think I have another question to Mr. Lasker, and that is, and I, before then, I'd like to have a motion from you to admit this, because I think that this is an addition, would be an additional.
Yes, and move that if they want to be group exhibit A for the 28th and group exhibit B for the 29th. Adam, I don't know if you have access to that, but I don't know if that conflicts with any exhibits that were numbered and lettered by the hearing officer. I guess this could be Rule 20 hearing.
Yeah,
It's probably important.
yeah. You see a group exhibit 1 and 2 then.
Right, that's what I see.
Like a A, B.
So
But I would ask that if we're going to recess and call again at another meeting, to what purpose?
well,
And again, what would you like from the objector?
well, and then that's where I'm trying it back to Adam. I think we can review this on our own, but there's another option of reviewing it back to the hearing officer.
There is.
So,
And that's, one of the things I was thinking is that, as I pointed out, my concern is that the hearing officer's recommendation is so focused on the affidavits and the barbecue, and now we've got this additional information that may have changed his mind, that it's, on the one hand, it's a little unfair that we would perhaps reverse him on a final decision based on evidence that he didn't have, that should have been presented at the hearings, right? On the other hand, we're also running out of time, so I would say that we would want to remand it quite quickly and have the case heard quite quickly.
Just another quick point for you guys to sleep on is that there are multiple lines where there were signatures, addresses that then were crossed out because he did evidently some type you'll notice that there's multiple extra addresses that he went to that aren't included in this time frame, because I couldn't see an address, so I didn't use an address. It would be unfair to make up an address, and they're not in. So you know, those extra addresses are all in, would need to be, you know, conceptualized as more walk time.
I'd say the two options really would be either enter and continue the Rule 20 so that you can further look at the record and come back and continue the Rule 20 hearing. Or we remand it to the hearing officer for one last hearing with instructions to consider this evidence, any other testimony or evidence the candidate wants to supply, and just see if that changes his mind on the outcome. Because I do wonder if, having been presented with this detailed walk time information, would have changed the hearing officer's mind. Because frankly, it's kind of changed my mind as I see it.
So,
Because I'm reading the hearing officer's recommendation, you got conflicting affidavits from people, yeah, I signed it too early, but then the same person says I signed it too later, you know?
The hearing officer must hear this by, I would say, no later than Tuesday.
Yeah. And enter a decision by Wednesday, and
Then
So
it
we
comes
could
back to
have it
us.
by Friday.
Or we could just keep this matter till Tuesday.
I guess my question is this, I mean, I understand, checking the hearing officer and allowing them to, they didn't have the records in front of them, and, you know, we were doing it kind of novel, but,
I'm concerned with time.
And the rules specifically allow for new evidence.
they do, if it's compelling. Tell me, Adam, about notice to the candidate in both of those scenarios. Is any further notice given to the candidate that, because counsel Kane's not here, so if we do remand, will notice be given to the candidate?
Oh, yes, we would issue an order from this electoral board based on your vote. The order would be sent to both all the parties and the hearing officer to inform all three of those people that the case is going to continue. And the way that our template document for that works is that we would set the hearing date, put that in the order, and I hope that it works for the parties.
I'm saying, if we kept it here, same thing?
If we kept it here, there's not that same, we would just be entering and continuing Rule 20, so we don't have a specific form order for that, but I would certainly reach out to the candidate and let them know.
And then what, in both cases, which I'm talking from timing here, in both cases, what are we looking like in terms of the candidate has to have time to review this and be able to respond to it, correct? So how does that affect the timing?
Well, it could all be sent to, does the candidate have an email address that he was using?
Yeah, I mean, has this been?
Yeah, I would assume that
delivered to them at all?
that the hearing officer would not have let it move forward without an appearance and emails, the address.
But have you delivered any of this evidence to him at all?
No, it was prepared for, there's,
Yeah.
I'm not being facetious, but that's what I
I got it,
planned
I got it.
to handle. The address is williamsfor10thward@gmail.com.
Williams for what?
10th Ward @gmail.com. And I'm assuming it's accurate,
Hold on,
because I think the G is from Google.
You said Williams for the 10th ward? 10th?
Oh.
15th.
15th, I guess. I apologize.
His appearance has a phone number.
Yes.
We have a whole new
That's a whole
issue.
nother issue, right?
I was trying to read the carbon copy.
My only concern is making sure that if we don't prejudice the candidate by not giving him enough time to review this, that's all.
His appearance form does not, he actually filed two different
He
appearances.
did, right, and I don't see the email address on either one of them, although I don't see is there a space for an email address on this
Yeah,
appearance?
right above the signature line, I agree to accept service by email. email address.
Yep, there it is, right over there.
But usually the hearing officers ask on the record for an email address.
Well, and I can get in touch with the hearing officer, it's very likely, well, it's possible the hearing officer was using emails in exchange. Yeah, that's.
I'll look and see if there's more.
Madam Chair, I'll defer to you in terms of what procedure you'd like to do. My only concern is making sure that the candidate gets notice of whatever it is that we decide to do, and has the opportunity to get these records appropriate time to be able to respond, considering the fact that Monday is a holiday.
So this is a copy of the appearance for John G. Williams that's not even in the case file. Let's see.
Yeah.
This is from the date of the 10th. Williams 415Ward@gmail.com. He's used consistently both under receipt and the file his nomination papers and on this appearance, which is not the same as the one that's in the electronic.
And would we be able to email this information to the candidate?
Yes.
Okay. Then I think that would,
Is this everything right
give
here?
him,
Or is this?
there's two packets.
If you, do you want to take possession of the copies that I made for him, which haven't been leaked
Yes.
through by anybody?
That would be
Yes.
great.
And be responsible for that?
So let's,
Where's your
mark
counsel,
these.
what's your counsel service?
The one, let's mark these, the one that, with the cover sheet that says Joseph G. Williams and, miles 1 through 8. Can we make that,
Well, that should be
They're dated.
pages 1 through 8. They should be
28 August 18 and
28
29.
August
oh,
18.
28 is,
I see.
candidates exhibit A. And then the one dated August 29, 2018.
Oh, this is objectors exhibit.
I'm sorry,
Objectors.
objectors, thank you. And, the, packet with the top stating August 29, 2018 is objector exhibit B. And they are, the motion is granted and exhibits A and B are entered into the record. Okay. So I think, Mr. Lasker, the goal would be to get a decision by, that we can, enter, by next Friday.
And so I think we should just enter and continue this. Is that what you're proposing?
Well,
I think that's gonna be faster than remanding it.
okay, so that means that we would enter and continue this till Tuesday, so that we can consider it and then have, if we don't have a decision written by that time, we will definitely have one by Friday.
Yeah, and it can be on the agenda for final decision, and then, so I can serve these things on the candidate tonight, inform him that the case has been continued till next week, Tuesday, keep your eye out for the agenda, start plan. And then, if he shows up, we can get his testimony, he'll be invited to bring whatever evidence he wants to counter this. And, if he doesn't show up, we will give him 2 tries.
Yeah, I think we should inform him that he may present evidence, any evidence that he chooses, including testifying.
Yes.
Okay.
I will copy the hearing officer and Mr. Urban and Mr. Nail.
So we're talking Tuesday the 22nd.
Right,
Okay.
okay,
Mr.
at
Urban.
9:30 a.m.
Real quick, after the signature exam, the candidate was above by, was it 83
Yes.
signatures? If you could calculate what it would be if these two, either or both of these packets were not to be considered.
Yes.
We don't need it today, just
You know,
Tuesday,
I do have a,
because we don't know which of the signatures in these packets were sustained and which were
Okay.
overruled.
the exhibits that you have are as far as I got working from last night until this morning. There are other sheets that I just didn't get to go line by line. The Google Maps app lets you put in an address and then add an address for a destination, but it gets down to like 6 or 7, and it says you can't do any more, start over. So, if you'd like to give me a certain amount of time to supplement these with the rest of them, and present them to Mr. Williams, because this is a subset of what he actually says he did on those 2 days. And it's, you know, that's my point, is it's just not physically possible for him to have done what he said he did. And this is a subset, and we're past physical possibility.
I'd like to get this stuff to him tonight, and I think that this is what was presented in the hearing, and maybe, maybe one of you commissioners would disagree, but I think this is compelling. I think that it serves its point of showing the impossibility based on timeframes.
So I don't think we need additional.
No,
No more Google for you.
Made the point.
There's several trees in the area that I have not killed yet. And I've got my eye on them.
Speaking of which, you handed me your copy of
Okay.
Mr.
I'm
Williams'
buying
hearing.
stock in Xerox now.
Okay, so we will continue this Rule 20. Mr. Lasker, would that be correct to continue this Rule 20 till Tuesday?
22nd.
January
22nd.
22nd at 9:30 a.m. And we will provide notice to all the parties electronically, but you know.
And those exhibits will be
And
provided by the
those, we
board
will
to
provide,
Mr.
we'll
Okay.
scan
I
those
want to make sure
and
that he gets.
provide those exhibits to the candidate.
Thank you.
Okay?
Thank you, sir.
Thank you,
Mr. Irvin.
Just like no
I mean,
case.
it's not final action.
Right. Okay. That concludes the,
Oh, we need to docket the race.
that concludes the Rule 20 hearings. Next are some final decisions. Once again, we will group these decisions. We have 2 candidate withdrawals. The first one is number 14 on the list, Alan La Rosa Lier versus Patrick Shine, 19 EBALD-091. And Charles, number 17 on the agenda, Charles Shute versus Patrick Shine, 19 EBALD-107. In these 2 cases, the candidate has withdrawn. Is there a motion to dismiss the objectors' petitions as moved due to the candidate's withdrawal?
So moved.
Is there a second?
Second.
Motion passes, and these 2 cases are dismissed, and it's therefore ordered that the name of Patrick Shine shall not be
Well, we
printed.
didn't vote. Second, we don't.
Oh, all in favor?
Aye.
Motion passes. The case is dismissed, and it's therefore ordered that the name of Patrick Shine not be printed on the ballot for the municipal general election. The next cases, the candidates, the objections have been overruled. The first is George Brown versus Essie Hall, 19 EB-ALD-012. Related case ALD-135, candidate for the 9th Ward. Paul Reyes versus Tanya G. Patino, 19 EB-ALD-015, candidate for the 14th Ward. Number 7 on the agenda, Marcel Bright and Darrell Lenoir versus Jewel R. Easterling Smith, 19 EB-ALD-032, candidate for the 8th Ward. Marcel Bright and Darrell Lenoir versus Fahim Shabazz, 19 EB-ALD-033, candidate for the 8th Ward. Gina Zuccaro and Emma Jean Robinson versus Jasmine Jackson, 19 EB-ALD-065, candidate for the 28th Ward. Number 11 on the agenda, Grace Contreras, Michael Anthony Rodriguez, and William Anson Senior versus Jose Rico, 19 EB ALD-075, candidate for the 12th ward. Number, let's see, 15 on the agenda, Renee Elms, Peter Rivera, Renee Wozniak, Maria Orihel, and Evelyn Raza versus Rafael Rafa Yanez, 19 EB ALD-100, candidate for the 15th ward. Renee,
Skip that.
Skip
Skip
this
that.
is the case we just tabled.
that's right. Charles, number 18 on the list, Charles Shute versus Austin Bidas, and that is 19 EB ALD-109, candidate for the 44th ward. Number 20 on the agenda, Ava Thomas versus Essie Hall, 19 EB ALD-135, with a related case, ALD-012, candidate for the 9th ward.
Just asked for
And-
150, we already, did the final decision during the vote.
Right.
Session.
So I think that concludes that category of cases. Is there a motion to adopt the respective hearing officers' reports and recommend their decisions, overrule the respective objectors' petitions, and enter final decisions in favor of each of the aforementioned candidates?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The motion passes, and it is therefore ordered that the names of the respective candidates aforementioned shall be printed on the ballot for the municipal general election. In the following cases, we have overruled objections, but because we have other pending cases, we're not making final decisions. The first one is Mark M. Tannenbaum versus Zira Quadri, 19 EB ALD-081, with a related case, ALD-014, candidate for the 50th ward. And number 13 on the agenda, Mark M. Tannenbaum versus Majid Mustafa, 19 EB ALD-082, with a related case, ALD-062. Is there a motion to adopt the hearing officer's report and overrule the objections?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. The next group are cases in which the objections have been sustained.
Madam Chair, the first two on the memo here were dealt with in Rule 20 section.
Exactly. So we will proceed with number 3 on the agenda, Stephen Salzman and Terry Feingold versus Bill Morton, 19 EB-ALD-008, with a related case, ALD-056, candidate for the 49th ward. Number 4 on the agenda, George Brown versus Marsha Brown Williams, 19 EB-ALD-009, with a related case, ALD-136, candidate for the 9th ward. Latoya Peterson versus Bill Morton, 19 EB-ALD-056, with a related case, ALD-008, candidate for the 49th ward. Number 14 on the agenda, number 21 on the agenda, Ava Thomas versus Marsha Brown Williams, 19 EB-ALD-136, with a related case, ALD-009, candidate for the 9th ward. Number 22 on the agenda, Kevin Bailey versus Cassius L. Rudolph, 19 EB-ALD-138, candidate for the 20th ward. Number 25 on the agenda, Daniel David Gerhard Rogers versus Elizabeth Betty Arias.
So we dealt with this
Dealt with some
last two.
Gotcha, and the next two.
Yep.
And in each of these cases, for each of these cases, is there a motion to adopt the respective hearing officers' reports and recommendations, sustain each of the objectors' petitions, and enter a final judgment against each of the respective candidates?
So moved.
Is there a second?
Second.
Motion passes. Oh,
Call for question.
all in favor?
Aye.
Motion passes. The respective hearing officers' reports and recommendations are adopted in the aforementioned cases. The objectors' petitions in each of these cases are sustained. It is therefore ordered that the names of the respective candidates will not be printed on the ballot for the general municipal election. We have two cases in which the candidates have defaulted. The first one is Jessica A. Terry versus Sheila R. Scott. That's number 19 on the agenda, number 19 EB-ALD-121. And Kevin Bailey versus Sheila Scott, number 19 EB-ALD-140. Is there a motion to adopt the hearing officer's reports and recommendations, finding that each of these candidates Sheila Scott has failed to appear and has defaulted?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The respective hearing officers' reports and recommendations are adopted in the aforementioned cases, and it is therefore ordered that the names of the respective candidates will not be printed on the ballot for the municipal general election. I believe that concludes our list of cases for today. Next on the agenda is public comment, and we have two persons. One is Bill Morton. Mr. Morton? And we have, just so you know, a 5 minutes.
Thank you.
Okay.
Thank you very much for taking my public comment. I just wanted to say the electoral process that I've experienced, I'm a first-time candidate, and I've had so many questions, and I've wondered so much about this process, and I've learned so much throughout this time. And, you know, we came up with like over 500 signatures, but there's 473 minimum. And it's just interesting how if those two challengers didn't challenge us, I could have been on the ballot. And there's so, just watching you guys today, there's so much, it's a human, personal thing. It's like you're making decisions, and it can go either way depending upon how it goes, you know. And it just seems like I don't know. It's very interesting, and I thank you so much. And I believe that the two people who challenged me, the two candidates who challenged me, they just made me stronger, and I'll do better next time.
Well, thank you, Mr. Morton. And it is, and we have to look at each of the individual circumstances and apply the law and the statute to each of these cases. And as you could tell today, it was a little difficult at times. But we try to do our best. And I just want to say that we need more people like you who come in, and you may not be successful the first time around, but you've learned a lot. You've learned a lot, and there's always a next time, and I hope you're part of the process and you're successful.
Thank you very much.
I look forward to the day I see your name on a ballot.
Thank you.
Thank you.
And I'll just add, I disagree with Mr. Avila, who said this is pretty simple. This stuff is not all that simple inside at times. So keep learning.
Keep learning.
Thank you very much.
Take care.
Yep.
The next
Safe
person
travels.
is Trudy Leong. Good afternoon.
Good afternoon, board members. I really appreciate learning from this process, and I looked up the mission of the Board of Election Commissioners for the City of Chicago is to administer a transparent, impartial, and accurate election system. So I want to dwell a little bit on the transparency, because there were several things that happened during the records exam in which Mr. Morton, Bill Morton, and Ann Sullivan were at simultaneous records exams, and Ann Sullivan and he were on the outside of the records examiner. They were simultaneous, and the objectors were on either side of the examiner. So Mr. Moran couldn't even see the screen, and it was so noisy in the room that he couldn't hear the examiner oftentimes too. Sometimes she was mumbling into her scarf, and he really couldn't hear. So he missed some of the objections that he could have gotten into, and he wanted to. And the same thing with Ann. She missed some, and then Bill wanted to jump in and object for her, but he wasn't allowed to. And yes, the hearing officer did allow to. And then of course I heard Frank earlier, Mr. Avila saying that the hearing officer didn't allow him to speak on another objection. So if possible, may we have cameras to record hearings so that for the sake of transparency. And I also wanted to comment on inconsistencies between the two challenges. Because there were two challenges, but for the same signature, there were inconsistent results. For instance, this is concerning case 008 and 056. So for page 1 and the line 1, for page 1, the total signatures were inconsistent. Latoya Peterson said that there were 510 signatures, while Stephen Salzman, the other objector, said that there were 504. For the original ruling on page 4, line 9, Latoya, the hearing officer overruled the invalid signature and overruled not registered at the address. However, for Stephen's ruling, it was sustained as not registered at the address. On page 33, line 6, for the Latoya, it was overruled for invalid signature and not registered at address, while the Stephen challenge was sustained as an invalid signature. For another page, page 4, line 9, Latoya was overruled for invalid signature and not registered at address, and Stephen was sustained as not registered at address. For page 9, line 2, Latoya was overruled for invalid signature and not registered at address, while Stephen was sustained as not registered at address. For page 17, line 2, Latoya was sustained as not registered at address, but Stephen was overruled as not registered at address. For page 29, line 1, Latoya was overruled for invalid signature, and Stephen was sustained for invalid signature. For page 33, line 6, Latoya was overruled for invalid signature, and Stephen was sustained for invalid signature. And for page 55, line 6, no, this one is okay. But there were several others that we didn't have enough time to get into because we did want to campaign, and I'm campaign manager, and I'm also a student. So because of this process and how these simultaneous challenges made it so difficult for us to work. We know that you want to be transparent and you want to be fair, and we ask that you consider having the hearings filmed somehow, recorded, so that when we object, it's easier for us to show that what we're stating is true, that the hearing examiner didn't give us an opportunity to address the challenges.
Mr. Lasky?
Thank you, Ms. Leon. I want to just chime in here because I happen to know a little bit about these numbers you're talking about. Did you send us a communication?
I did.
Okay.
Yeah.
Because Mr. Holliday and I actually talked about this. I just want you to know that it's not supposed to work this way.
Mm-hmm.
Like you point out the two summary sheets showing different total signatures filed. Obviously, one candidate files one total signatures.
Right.
And then with the inconsistencies in the rulings, the way it actually does work is that the two objections, they both get programmed into the system, And as you probably observed, the records examiner is doing both of the objections simultaneously.
Right.
And so that one person who rules on each signature line one time per objection is then supposed to put the same overruled here, overruled here.
Mhm.
So the best we can come up with on those irregularities is that the keystroke was off, that the person made an error, because it's clearly not supposed to be that way. But I just want you to know that Mr. Holliday and I, we had actually sat down and talked about this and wanted to go in and apparently because of what you'd sent to us. So we appreciate when you do bring stuff like this to our attention. It is our goal to have these things be as absolutely accurate as possible. Human error is always a factor. And so I just want you to know that we had already spoken about this because of what you sent in. I didn't know your faces when you came in today, but all of a sudden I'm hearing these numbers that sound very familiar, and we've already talked about it. And so we're constantly trying to improve the situation.
I actually sent them on her behalf, not to change the results of the
Yeah.
ultimate recommendation of the hearing officer, but to show you there is a very large margin of error in this, and there is quite a bit of inaccuracies, and that's one case. But it does take a great amount of time to go over this to show all the inaccuracies in the Rule 6 process. I have in the past shown them, but I don't have time to sit down each case. Luckily, my clients did quite a bit of work, because Mr. Morris said if there's an accuracy, bring them, even if they don't exchange, hearing officer Joseph Morris, even if they don't change the results of the recommendation.
Ms. Leon, you also discussed the challenge of being able to see and hear during the records exam, which I
Yes.
think that could have been the root problem here. Because if Mr. Morton and the other watchers had been able to see better and hear better, then you may have seen these inaccuracies happen as they were happening, and
Exactly.
would be able to stop the examiner and point out these obvious discrepancies that we would like to correct anyway. And so I do just, if you intend to run again, Mr. Morton.
I do.
and Ms. Leon, if you intend to remain a campaign manager, please know that Mr. Holliday here, our Assistant Executive Director, does oversee that process and wants it to go as well and as fair for everybody as possible. So don't hesitate to ask for a timeout, and if you need to even escalate it to Mr. Holliday, we want to make sure that you can see and hear what's going on, and we
Yes,
don't want
and-
these inaccuracies.
Yes, and during one time too, the Wayne Fraser, one of the objectors' representatives, he stepped out for 2 extended periods of time during the.
Well, that's his loss. That's, you have to appeal the rulings as they're made in order to then follow up and challenge them later. So if the objector's lost, if he steps out, we're gonna proceed without him, on either side, to their own detriment.
If I may say, again, Ms. Leon, thank you for coming in. And I would ask council and Mr. Holliday if maybe we could look into possibly building into the software of our program some sort of validity check, so that we do have 2 identical challenges, it will automatically check to see if they're the same, and then notify the examiner that they're.
Or that the ruling gets put in once, and then the computer system automatically
Applies them
that one
both,
ruling.
right. Let's look into that, because it's a very important thing that you raised and brought up to us. Thank you.
And the other thing that I would add to the point of being able to really see the screen, we do have setups of laptops and we're working that way, but in certain cases, maybe we do this, but where there are significant folks that are looking at a screen, we might want to have a setup where we have a mobile larger screen that people are making copies from the laptop screen so that everyone can see. That might be a better way, especially when you have a number of people that are looking at one page.
Yes, and Ms. Morton couldn't hear the hearing officer too. She was mumbling and then speaking into a Skype, and it was very noisy in the records exam room. It would be very good if somehow it was recorded, so that at least when we address the issues, then you have evidence before you.
Thank you.
Thank you.
Thank you so much.
Thank you.
Appreciate it.
Mr. Avila, did you state what,
Yes, I do have I would ask to make a public comment here today. First of all, I want to compliment, I always start with a compliment, which is always nice, right? That usually the city of Chicago, the Chicago Board of Election Commissioners administration results, usually, not always, but are usually better than the counties, and that the nomination paper and electoral challenges in particular are done much more accurately and professionally than the counties. And that's the only, well, I've done some stuff at the state, mostly it's the city or the county. And then Mr. Holliday in particular has always been excellent and professional and helpful. And the vast majority of the staff, almost 100%, have been professional and helpful and are very competent at what they do. And much more competent than the county clerk, at least the last occupant of the county clerk's office and the county electoral board. So that is my compliment. However, that's not always the case. Now I'm just going to start, since these were my clients. When Mr. Morton came to me, I said, you can pay me, but I cannot get you on the ballot. You only have 40 signatures over the required minimum, unless you went door to door in a poll sheet and know each one of these voters and can give me 100 affidavits very early on in. There's almost no way I can get you on the ballot, but he said he wanted to go through with it, wanted to go through with the process, and indeed he did hire me. Even I told him, keep your money, don't do it. We wanted to see how it went. And when I first learned about this, it was actually the case in the 34th Ward. The name is eluding me now, but the hearing officer was Yolanda Sear. There was 2 objections. One was by Attorney Giaconetti, one was by Attorney Cleary, with greatly different results. And those greatly different results caused a complete lack of accuracy. Regarding the lack of accuracy, I think that you have to put it in something similar to, same thing with your handwriting expert, which had great variances this cycle, especially after you received the new handwriting expert as of the last cycle, where on one aldermanic candidate in the case of the objection of Ramos to Majid Mustafa, the objector received, the candidate received 97 more signatures after the handwriting expert, but in the case of Pat Horton, she received 200 less. Now, admittedly, one's citywide, one's aldermanic, but the other aldermanic, the candidates received 40, 50, 60 less. So like the response that we received Mr. Lasker, they're not always in the case of the candidate, and the rate of change was 10 to 1 in favor of one party. That does not seem probable to me. And so I think what you have to do is look at it like you would do for an expert witness in a Daubert hearing in the federal court, or a similar hearing in the circuit court of Cook County, state court, is that one, what is the qualifications, either of the caller or the person, 2, what is the methodology, the algorithm, the calculus, and then 3, what is the margin of error? There may be a 4th element I'm listening, or prong, but I'm basically getting the main prongs, maybe not exact wording, but in paraphrasing. And there is a margin of error, although they've overturned the case that said that substantial compliance and signatures, indeed there is a margin of error. To think that somebody could be up or down by 1 signature is a faulty reasoning. Also, I don't believe that you have sufficiently pushed for electoral reforms, for reduction of signature requirements, which here we went up from 473 in the 2015 elections, from 2011 from 90 to 120. Seeing in some wards with lower voter turnout, such as the 49th ward, 25 and 30% of the 22nd ward, 15th ward, those wards, of the voter turnout. Even though I know the federal courts have not had those kind of levels, they found, okay, they're constitutional. I think practically they're not. And what we see here is in a transitional year, you have actually a low number of candidates running, and some wards without any opposition after that. But I must say, I am very disappointed in 2 things. And in the case today brought before you, I think we have an issue here, which is the Briscoe versus Custer Prosper, Robert Briscoe et al. Versus Stanley Custer, 435F 2D 1046 7th Circuit 1971, that the board cannot change rules without notice. And you can't have contradictory decisions standing on its face, because then we're not on notice, we don't know how to argue it. And I know my time is coming up, but I'll leave you with one thing. I am doing administrative reviews on the 2 court cases. And I hope you do not do what you guys did to Andrea Rayla on election day, which I know Ms. Giles said, it was only in the morning, it only affected tens of thousands, not that many, wouldn't have affected the election. In the afternoon, it was still going on, and yet nobody's head rolls. For 100 signatures on the race for state treasurer, a head rolled as a fall person. But there was no heads rolling on that, and that affected people's voters' rights, and it was horrible. And if we were in a Japanese type of situation during the samurai days, some of us would have to, you, not me, would have to kneel down, accept the seppuku, and have our heads cut off, because it would have brought shame and dishonor upon your own board. And I believe with some of the decisions we made today, we are bringing shame and dishonor on your board, and I'm really very disappointed in terms of that integrity, and I believe you have a Kesper v. Briscoe situation here, and I hope what happened to Andrea Rayla never happens to another candidate.
Thank you. Okay. Oh, I'm sorry, did you?
We don't have one, we only have 3.
Did you? Yeah.
None?
Okay. Did you,
Well,
Luana,
Maybe I should help.
Yes.
Yeah. Do you want me to just say it? Just fill it out?
if you could just put your name on it. just-
Okay, then.
Trish, can you just go
Trish,
ahead?
I'll order it. Thank you. You know, I just want to thank you all for me to come before you and just speak before you real briefly. I just want to share a few things from my heart, okay? As I went through this process, you know, and I filed my petitions, while I was going through the process, I noticed a few things. The recapitulation sheets that I received, and I'm supposed to go and have this hearing, and I look at, while I'm going through the hearing, and I've been there from day one to the end, on my recapitulation sheets, where it says that I'm being challenged, then all of a sudden I hit a blank spot, and then the person who's challenged, you know, just putting in the information says, oh, well, you have a challenge on this sheet, but it's not showing on my recapitulation sheet. Why did we stop and go back, find what it is, put it back in, and then I get a ruling on it, without my knowledge that there was something there? That's one. While I was there also, there were sheets missing.
What it was? What the
Yes,
challenge?
that's what happened, and it happened over about 50 times.
But was it a particular?
There were quite a few, and they're in the numbers of 700 and more. But for sake of time, I wanted to make sure I get all this in. There were sheets missing, and then we had to stop and go and find sheets that were pulled from there. And they had to find them and go make more copies and come back and make sure that we go through the process. Now, we had signers not at address shown. These people I went and I got signature from. I know who they are. We had seniors that have signed the petitions. I know who they are. I work hard at making sure I get signatures. And then, some of those signatures were outdated. I know Mr. Jackson. Mr. Jackson now is sick. He has Alzheimer's. He shake a little bit. And when he signed, they said, oh, well, that's not genuine. But I know him. I know his signatures are good. And this went on and on and on because I get my signatures. Address missing, one number. Someone lives at 1401, but it's in as 4101. Oh, well, you can't have that. Okay, fine. Okay. We need to update the system because I'm asking, well, how is this information going in the system? Oh, human error. Well, your human error's got to be my fault. And it's not right. People change their signatures, especially the young millennials. They may start out and they sign with their full name, and then when they get older, what happens is that they say they want to loop it now. But when you check where they printed and they had their name, you can see that's the same person. But of course, I'm not going to get that, okay? That's stricken away from me. And then another thing is that my question is how does thousands of people that I know that I don't get credit for because they're the signature line A that's not registered at address shown, and my objector, when you put in his full name, is not registered
registered at his address shown, but yet and still, he's not stricken. But all those thousands of people that I have are stricken. I don't understand. I don't understand. So we need to update the system. Anyone who's registered to vote, I know you can sign up at the DMV. Why can't we update the signatures? Because there's a lot of people who I know who have taken the time and says, we want to see you on the ballot, and who has signed for me. And I'm hurt. Yes, I am. Because I was there from 9 in the morning when the polls opened till 7 o'clock at night in the cold, no lunch, no dinner, getting these signatures from registered voters. And now I find some of them don't live where they where they're registered, and you let an objector come in and tell me, because if you type his name in, he's not there. And then they say, oh, well, he made a mistake. He moved, and he didn't mean to move his registration. Well, explain to me how he did it twice. He lived at 53rd Street, but then he moved to 64th and Inglewood, and then after his girlfriend's apartment, she bought a condo, and then he moved his address over there. And then when he signed as an objector and realized that he didn't have it right, then he run back, and then he switches to his mama's house? I don't understand that. I'm willing to accept whatever it is that you have to give to me. If I didn't do it right, then I deserve not to be on this ballot.
Kangaroo court.
But there's so much. I'm going to end with that. God bless you. Thank you. And I will appeal. Thank you. God bless all of you. Have a good day.
Thank you.
Good night, Pat.
Good night.
Good night, Frank. Bye, kangaroos. Thank you, and happy birthday.
Oh, yes.
What she needs is
That's what we're still doing.
Yeah, it's good to sit up. Thank you very much.
Thank you, Mr. Martin.
Okay. Yeah. 'You're ready. These are good. These are.
Yeah, they look.
I got them from my grandpa. Hand me downs, and they're really traction.
Oh, really?
They're really good with the weather. They don't leak. Better than my regular shoes.
What kind of shoes are those?
Yeah. Yeah, we're gonna wait for the fit. No, whatever you want to do. Whatever you want to do. It's hard losing.
Tuesday, January 22nd, 2019 at 9:30 a.m. Is there a motion to recess?
So moved.
Is there a second?
Second.
All those in favor?
Aye.